Hello, everyone, and welcome to week 10 of LAWS11068 Alternative Dispute Resolution. So we're now in week 10. We've only got 2 more weeks to go. And in this particular lecture video, we're going to be talking about ethics and standards. In the previous week, we talked about some legal issues pertaining to confidentiality, enforceability of settlement agreements, and we also talked about the immunity of third-party neutrals. We're going to be, in a sense, looking again at the issue of confidentiality because that topic actually relates as well to the principle of ethics, which mediators often are confronted with. So we're going to be examining the role of ethics in the practice of alternative dispute resolution, especially in relation to matters of confidentiality. In particular, one of the ethical questions that often arises in relation to mediators is, or those who are involved in a mediation session, such as when there is a lawyer or a barrister who is involved. What if they come across information that was provided and it happens to be misleading? Would there be a need on the part of a solicitor who is involved in a mediation proceeding to actually inform the court or the other party? So that's, and if that happens, what about the rules on confidentiality, especially in relation to legal privilege? So what exactly are the rules there? We're going to be looking at that. We're also looking at matters of accreditation and standards. One of the basic questions we need to ask is, can anyone just call himself or herself a mediator? Or does one need to get accreditation? In relation to that, if somebody claims, if somebody says that he or she is a mediator and uses puffery, makes exaggerated claims in order to get clients, what happens then? Will there be a breach of law somewhere? How about lawyers? Can they act as mediators, and what would the implications be? And what particular standards govern the conduct of lawyers if they act as mediators? And so these are some of the questions we're examining in this lecture video. And so on completing this topic, you should be able to discuss and explain standards of competence and practice, some professional registration and accreditation issues, ethical standards of behavior, particularly of mediators and lawyers involved in mediation. And we're going to be looking as well at relevant case law, including the Mullins case, particularly in relation to the topic I mentioned, or the issue I mentioned, where a lawyer or a barrister comes across information that appears to be false or misleading. Is there a legal duty on the part of a lawyer or mediator to inform the court of such falsehood, and or the other party if they may have been misled by such information? And if that's the case, how is that to be done, and what is the implication of that in relation to the rules on confidentiality as well as the rules on legal professional privilege? So we're going to be examining that as well in this lecture video. Let's begin first about getting accreditation as a mediator. The important thing we need to know is that anyone can be a mediator. As far as the mediation industry is concerned, or the mediation profession is concerned, it is not regulated. So anyone can be a mediator. Anyone can call himself a mediator in general, because number one, if somebody wants to become a mediator and in that sense be accredited, that is a voluntary process. But there is no legal requirement that somebody has to be accredited as a mediator in order to practice mediation. So mediation is not a regulated industry. In the same way that I think the accountancy profession and certainly the legal profession are regulated. So for example, not anyone can just say he or she is a certified public accountant or a chartered accountant without actually being accredited or being registered. And no one can claim to be a solicitor when, for example, he does not have a practicing certificate, such as with the Queensland Law Society. But having said that, it means that anyone can say that I am a mediator. And when that person says he or she is a mediator, it doesn't really tell us whether or not that person is in fact accredited as a mediator. And as we will see, without first talking about the mediators who are family dispute resolution practitioners, those who are accredited mediators, these are typically the ones who are accredited under the National Mediator Accreditation System. And what this means is that under the National Mediator Accreditation System, there are then certain bodies which have been accredited by the under the system, by which they can then actually accredit people or individuals as mediators. And then we will realize, which we're going to be examining in greater detail, that there will be training and assessment requirements in relation to becoming an accredited mediator. Now, so having said that, I mentioned that anyone can be a mediator, but for somebody to become an accredited mediator, that person has to be accredited under the National Mediator Accreditation System. Now, even if somebody claims to be an accredited mediator without really mentioning what kind of accreditation it might be, for all we know, it's an accreditation by some unknown, American body or some other overseas body, which can, in a sense, be deceptive, as opposed to accreditation under the Australian National Mediator Accreditation System. So, in other words, I call your attention to the fact that there can be, claims which are invalid or, to an extent, deceptive claims in saying that I am a mediator, but in fact, or somebody can say I am an accredited mediator without actually clarifying that accreditation is actually an accreditation by some body or organization overseas, which may not have the same robust systems or standards in place as that found according to the Australian National Mediator Accreditation Systems. And in that case, is there a breach of law somewhere? So we're going to have a chance to examine that in greater detail in a short while. Now, but in addition to the general mediators, or those who are accredited mediators under the National Mediator Accreditation System, there's also another group of mediators who we've discussed previously, and these are the family dispute resolution practitioners, who are in fact regulated under the family law, Family Dispute Resolution Practitioners Regulations 2008 Commonwealth. So these group of mediators who call themselves family dispute resolution practitioners, they specialize in mediating family law matters, and only they have the ability to sign the required Section 60I certificates under the Family Law Act of 1975. So we recall that before a person can make an application to the Federal Circuit and Family Court of Australia for an order in relation to a parenting matter, they must first have undertaken mediation or dispute resolution settlement before a family dispute resolution practitioner. So it is a requirement prior to the acceptance of such an application, except where there's evidence, as we know before, evidence of family violence or domestic violence or family abuse, or or instances where there is a need for the court to consider the family matter application. But in general, there is a requirement that for an application to be considered by a court, there has to be a Section 60I certificate that has been issued by a family dispute resolution practitioner. Now, so these, in other words, these family dispute resolution practitioners are the only ones who can do so, but they are regulated and accredited under the family law, Family Dispute Resolution Practitioners Regulations 2008. And we need to know that there are different training and assessment requirements under each system, whether the system is based on the requirements for mediators who are family dispute resolution practitioners, as opposed to the broader field of mediation services and of accredited mediators under the National Mediator Accreditation System. Now, in relation to the Family Dispute Resolution Practitioner Regulations 2008, there are requirements in relation to qualifications and competencies, such as in relation to educational qualifications, training and professional development. There are also requirements in relation to suitability and prohibitions against working with children. So in other words, if a candidate applying to become an accredited family dispute resolution practitioner wants to become one, that person must have complied with the requirements about suitability and requirements that that person is not prohibited from working with children. There are requirements about applications for accreditation and obligations as conditions of accreditation, as well as professional standards. What is important to know here as well is that somebody who is a family dispute resolution practitioner or accredited as one, as mentioned, has certain obligations as conditions of accreditation. And in the event of a breach of these obligations, the accreditation of such an individual can be suspended or canceled, subject to the rule of procedural fairness, in the sense that the cancellation will always be based on an opportunity on the part of a member or an accredited FD family dispute resolution practitioner to be heard. And for those whose accreditation, for example, are suspended or canceled, there is a review mechanism based on the administrative. There is a review mechanism through the Administrative Appeals Tribunal. Now, those who are accredited federal family dispute resolution practitioners, they obviously as well have professional standards. But what this means is that an individual is not permitted under the law to claim to be a family dispute resolution practitioner without being accredited under the Family Dispute Resolution Practitioners Regulations 2008. Unlike somebody who can just say, I am a mediator without actually having any accreditation. That is permissible. Now, let's talk about the voluntary accreditation mediation, the voluntary accreditation system for mediators. We emphasize the fact that it's voluntary because, as we said, anyone can be a mediator without actually getting any accreditation. We're going to be examining why it might be to the benefit of an individual to be accredited, and why it might be to the benefit of the public to actually engage a mediator who happens to be accredited under the under the system. So, first of all, for those who seek to be accredited under the National Mediator Accreditation System, they would have to apply. And if they get accepted, there is a requirement that they comply with the nationally accredited mediators practice rules and practice standards. And in doing so, then, what it means is that for those who are accredited as mediators under the NMAS, or the National Accreditation Mediation System, they need to know that as far as mediation is concerned, the purpose of the mediation is to maximize the decision-making of participants. So in other words, remember, as far as power is concerned, the power to make a determination as to outcomes belongs to the participants and not to the mediator. And it is important that mediators are aware that their duty or their involvement relates to facilitating a discussion or the negotiation between or among the parties in order for them to reach an agreement. But mediators do not advise, do not evaluate the respective positions of the parties, or do not determine or adjudicate a dispute. That is something that belongs solely to the participants. And it also means that the mediator cannot compel or force or coerce the participants into entering into a settlement without their consent. It's also important, as part of the voluntary national practice standards, that when a mediation session is started, the mediator must ensure that there's an outline and an explanation of the process given to the participants, so that the participants are aware what they can expect and what they should be doing. It's also important that in doing so, the participants be made aware, for example, about the rules of confidentiality. And there's also the requirement that in doing so, the participants are aware that questions about their safety and security are also very important considerations in the way that the mediation process is conducted. It also means that a mediator may be bound by existing professional and organizational requirements. And because remember that as far as mediators are concerned, although they are accredited under the National Accreditation National Mediator Accreditation System, so under the NMAS, remember that a lot of these mediators actually work under specific mediator bodies, and these specific mediator bodies may have their own practice guidelines and organizational requirements and ways of doing things. So, and in that case, therefore, in addition to whatever voluntary national practice standards there might be that have been formulated under the National Mediator Accreditation System, there is also a requirement on the part of mediators who work with or belong to particular mediation bodies that they comply with the requirements of those particular bodies. It's also important that in relation to the voluntary national practice standards, mediators must be trained in recognizing power imbalances and issues concerning control and intimidation, and take appropriate steps to manage these. There are a lot of ways at looking about power issues, not only power issues on the part of the mediator, because certainly the mediator does wield some power in the way that the mediation is conducted. But at the same time, there can be power imbalance as between the parties. So for example, it might be quite common where there is an allegation of domestic violence, for example, that perhaps the male may exert some power over the other party, which means that the other party, especially the female, may have difficulty expressing her own views, or may feel coerced into agreeing into particular settlement conditions against her will, out of fear or intimidation from the other party. And these are matters which the mediator must recognize. It can also mean that as far as the power issues are concerned, it can be power issues in relation to somebody who is wealthy, somebody with power, in a real sense, like an employer who might be mediating with an employee. And in that case, it's also critical for the mediator to be aware of these power issues to ensure that the participants do have an opportunity to actually be heard and enter into any possible settlement agreement with an informed consent, and with the ability that it was really based on their own volition and choice. One of the other requirements of the national practice standards is that the mediators must conduct the process in an impartial manner, and they must adhere to ethical standards of practice. So it is important that the mediator must be able to demonstrate and show to the participants that he or she is neutral and objective. And there should be an effort at avoiding the apprehension on the part of the participants that the mediator may be biased or play favorites, because in doing so, it will only poison the mediation process and lead to a failure on the part of the participants to eventually settle a dispute. One of the other national practice standards is the principle of confidentiality, which we discussed in the previous week. It's important that the mediator must respect the confidentiality of parties, and the mediator must also be able to clarify expectations concerning confidentiality before the mediation begins. And in this regard, it is common in terms of mediation practice that the mediator informs the participants that anything that they say or do in the course of the mediation are covered by the rules on confidentiality. And as we know, the rules on confidentiality may be based on the common law, in the sense that when the parties are actually entering into negotiations for the purpose of settling a dispute that is covered by the rules on confidentiality, as well as the rules on confidentiality based on contract or an agreement between the parties or the mediator and the parties, as well as certain statutory provisions, which we discussed last week, where where certain statutes provide that mediation proceedings are meant to be confidential. There's also a requirement about competence of the mediators. So in other words, before somebody can become a mediator, there are requirements about educational qualifications or training and continuing professional development and so on. There's also a practice standard in relation to interpersonal professional relations, so that the mediator must have a respectful relationship with professional advisors, other mediators, and experts who complement mediation practice. It's important as well to recognize that as far as mediation processes are concerned, as we already know, it might happen that there are professional advisors who are asked to get involved in the process of mediation. This could be tax advisors, this could be accountants, this could be counselors, and so on, just for the purpose of enabling the parties to be in a better position to reach an agreement. There's also a requirement that as part of the national practice standards, that the mediator observes procedural fairness. In other words, the mediator must conduct the process in a procedurally fair way. In this sense, at its core, procedural fairness would mean that the mediator, number one, really acts in an impartial and objective manner without playing favorites, but at the same time, enable the parties to be heard, to be able to be given an opportunity to have their voice heard. Again, part of the national practice standards means that the mediator must be aware that he or she has no advisory or determinative role in relation to the content of the dispute. So the mediator does not provide advice to the parties. The mediator does not make a determination or adjudication as to the content of the dispute or the respective legal rights or positions of the parties. The mediator can only advise the parties in relation to the process by which the mediation can be facilitated or negotiations can be facilitated by a mediator between or among the parties. The parties must also be informed or must be made aware that the mediator may suspend or terminate the process if he or she perceives that there might be harm or prejudice that would befall or can befall one or more of the participants. There's also a requirement that the mediator must explicitly advise parties concerning charges for mediation services. And finally, the mediator should ensure that any public statements promoting the mediator's business are accurate. So in other words, for those who are accredited, they cannot just make wild claims or exaggerated or false claims about their business, not only because that's part of the national practice standards, but as we see later on, it may be in breach of the Australian consumer law, especially in relation to the requirement that those who deal with consumers must not engage in misleading or deceptive conduct. Okay, so we've discussed that. We've discussed the voluntary national mediation standards for those who are accredited under the National Mediator Accreditation System. Let's just speak a bit more about procedural fairness, because this can be an area which can crop up, especially in relation to some participants feeling that when they entered into an agreement with the other party or the other parties, they feel that they were coerced or that they did not really give their full consent. So in a way, some of the participants may feel that the contract is void because either there was no meeting of the minds, or the contract is voidable in the sense that their consent was actually vitiated based on pressure or intimidation or coercion, either coming from the mediator or some other participant. So in relation to the rules on procedural fairness, the National Mediator Accreditation System practice standards provide that a mediator will support the participants to reach any agreement freely, voluntarily, without undue influence, and on the basis of informed consent. And it should also be clear that it is the primary responsibility for the resolution of a dispute rests with the participants. It does not rest with the mediator. The mediator also must not pressure participants into an agreement or make a substantive decision on behalf of any participant. This has to be really emphasized, because there might be the danger that there are some mediators, in order to be able to make, individual mediators, in order for them to be able to make claims that they are successful mediators, out of, let's say, out of the many mediation sessions they've had, they'll probably say that, I've resolved 60% of these mediation cases, and I've come across some of these mediators. We don't really know, in the first place, to what extent these claims are true, but it also raises the question as to whether or not the agreement entered into by the participants was entered into really voluntarily and without any undue influence or undue pressure. So there is an emphasis under the National Mediator Accreditation System that the mediator must observe procedural fairness, and in ensuring that there should be no pressure on the part of the mediator to compel the parties to enter into an agreement. As far as the pressure is concerned, or undue influence is concerned, it could be statements coming from the mediator. Oh, but that you need to enter into this agreement, otherwise this is likely going to happen. Or you need to do this because we've been at this for so long. It's about time you reach an agreement between yourselves. Or for the mediator to keep on dragging on the mediation session for about 6 or 8 hours, or towards midnight or towards late evening, just to pressure the parties to enter into an agreement. And these potentially can lead to a breach or violation of the rules of procedural fairness. The other thing that we should consider, however, is that although we said that mediation at its core is all about the mediator facilitating a discussion or negotiation between the parties so that they end up reaching a settlement between themselves, and so therefore the focus is on the process rather than on the content of the dispute. So and we said already that the mediator should not be advising the parties as to their respective rights. However, there is such a thing as having a blended process. When you speak, for example, of a blended process, what this means is that the mediator, to an extent, may focus on may focus on the process by which reach an agreement, looking at facilitating the discussion and the negotiation. But in a blended process, it may be possible for a mediator to somehow provide advice, in the sense of, we talked about conciliation. So remember, as far as the conciliator goes, the conciliator actually provides advice to the parties as to how a settlement may be reached, or what a possible legal outcome might be if it actually came before a court or a tribunal. So there's an advisory process, or there's an advisory role in relation to a conciliator. In mediation, there shouldn't be any such advisory role. However, it's also recognized under the National Mediator Accreditation System that there will be occasions when participants may want a blended process. What this means is that the participants may actually ask the mediator not just to facilitate, the process of discussions and negotiations, but somehow provide advice to the participants as to, how an agreement may be reached by them, or what the mediator thinks in terms of the respective legal positions. And under Section 2 of the practice standards, it may be possible for mediators to use a blended process whereby they provide advice. Now, such processes may involve the provision of expert information and advice, provided it is given in a manner that enhances the principle of self-determination. So in other words, at the end of the day, it's still going to be the participants who are empowered to make the decision, and provided that the participants request that such advice be provided. So the blended process, in the sense that there's a blending of the facilitation of the process of discussion and negotiations and the provision of advice, that is permissible, but only subject to the requirement that the participants request such an advice, and that it be done in a manner that enhances the principle of self-determination on the part of the participants. Now, as we mentioned already, as far as the National Mediator Accreditation System, mediator accreditation standards are concerned, the requirements concerning competence, credibility, experience, accountability, and so on. Now, so what would be the benefits of being accredited under the National Mediator Accreditation System? Number one, there is actually in the website an authoritative list of mediators of the training threshold and assessment requirements outlined in the approval standard. So as far as the public is concerned, if an individual is then listed as a mediator, that is a signal to the public or to consumers that, in a sense, that mediator complies with the practice standards, and also means that that person has met certain requirements and probably is competent and trained enough to become a good mediator, or is at least competent to be a mediator. So one of the benefits of being accredited then is that it signals to the public that, as well as meeting training and competency assessments, the individual has demonstrated the necessary good character and professional indemnity insurance cover to mediate under the standards, and that individual is part of a system that is concerned with consistency, credibility, and quality, and with ensuring that participants are given the opportunity to engage mediation professionals who exhibit and uphold these values. Now let's examine some ethical issues. Now, one of the ethical issues that have been raised by some of the authors or scholars pertaining to ADR is the question of the monitoring and the oversight compliance with the national accreditation standards. Now, even though there appear to be national accreditation standards, we recall in the first place that mediation proceedings or processes are meant to be confidential. So if they are meant to be confidential, how then would participants really be in a position to complain about the way that the mediation process was undertaken, or for the national body to actually know about the way that the mediation processes were conducted, when there is no requirement for anyone to provide reports to the national body in the way that a mediation system was undertaken. So that's one of the problems. And in relation to trying to improve mediation practice, how exactly would they be measured, and what exactly are the benchmarks? Because certainly there will be a lot of variation in terms of mediation practice, also in terms of the abilities and in terms of the values that are espoused by mediators, as well as the bodies for which they work for. So these are some of the questions. There's also the question about, can a truly national standard exist? Which can be problematic in the sense that there might be competing jurisdictions, for example, across Australia, and in every jurisdiction there might be different sets of values, practices, and ethics that especially coming from a relatively new field. There can also be the possibility of conflict between national standards, individual professional standards, and statutory schemes of ADR. So on the one hand, for example, as we see later on, when it comes to legal professional or lawyers, they will also be bound by practice rules as lawyers. So these are in relation to lawyers who may be acting as mediators. Now, these lawyers who are acting as mediators may be working under both their practice standards as lawyers, at the same time, based on the voluntary practice standards under the NMAS system. And whether there's a conflict, what happens next? So these are just some of the ethical issues. There's also the question about individuals operating in an adversarial profession, but the work may involve the conciliatory approach of ADR, or the facilitative role of ADR, which means that for those lawyers, for example, who may be acting as mediators, or for lawyers who may be participating in a mediation process to represent their clients, they may struggle with the role as working under the adversarial system, or a culture of treating the other party as an opponent, as opposed to trying to work towards an agreement with the other party. So there is often the view that these roles can conflict. There's also the question about collaborative law, that collaborative law as an alternative dispute resolution may be unethical, and we discussed this in the past. This is mainly because when it comes to collaborative law practice, for example, what it means is that the lawyers are involved in collaborative law, the lawyers, not as mediators, but the lawyers who are actively participating in collaborative law practice, agree that they both work towards reaching, or they all work towards reaching a settlement for all the parties. And in the event that there is no settlement of the dispute, that these lawyers who are involved in collaborative law practice can no longer represent their respective clients in actual legal proceedings. The problem, however, with collaborative law practice is that there appears to be a conflict of interest, in the sense that a lawyer is meant to ensure that the interests of his or her client are promoted. But in a collaborative law practice framework, that lawyer also has kind of a duty to try to consider the interests of the opponent, of the other party, in order for a settlement or an agreement to be reached. But to an extent, there are questions about conflicts of interests as to who exactly is the lawyer representing. So to some, there may be questions about the collaborative law practice being unethical. There are also some who argue that some dispute resolution practitioners may become involved in an authorized practice of law. We recall that, for example, in relation to conciliation, it is often commonplace for the third-party neutral, the conciliator, to actually provide advice to the parties in relation to their respective legal positions. The third-party neutral, the conciliator, for example, may talk about how the law works, what the law might be, what they can expect in a court proceeding or in a tribunal proceeding, and so on. But in doing so, it may be possible that, in a sense, that conciliator or a mediator may be undertaking the practice of law without really having a practicing certificate to practice as a solicitor, for example. So these are just some of the ethical issues. There are also those who ask, can an individual perform multiple roles, where a lawyer, or a mediator, for example, is a mediator lawyer on the one hand, but on the other hand, that lawyer mediator may then become a lawyer, may actually represent one of the parties in a later proceeding as a lawyer, and that raises questions is in relation to an unrelated matter, whether or not there might be ethical issues involved in doing so. It may not be in relation to the same legal matter, but it could be in a different legal matter. But the fact remains that in the course of doing so, the mediator, who then becomes a lawyer for one of the parties, then becomes privy to information that was expected to be treated in confidence, although it may not be used as evidence. But the fact remains that that lawyer would then have access to information that was intended to be confidential. We've also known that although ADR is meant to be voluntary in general, we now know that in many legal proceedings, it is now almost a requirement that the parties undertake alternative dispute resolution proceeding before commencing any legal proceedings, or even after the legal proceedings have commenced. So, for example, we mentioned that as far as family law matters are concerned, it is commonplace under the Family Law Act. It is a requirement under the Family Law Act of 1975 Commonwealth that the parties must first have undertaken family dispute resolution with an accredited family dispute resolution practitioner. So in that case, if there is a statutory requirement or an imposition, then that raises the question of whether or not ADR really is one that is voluntary, and whether or not ADR is something that is based on a choice made by a participant or participants. There's also the question of power imbalances, which can lead to coercion. We know that there have been some cases whereby there is the perception that a mediation, that in the course of a mediation there was some power imbalance, which in a sense may have compelled a party to enter into an agreement, or that a party was really unable to freely make his voice or her voice heard because of power imbalance. So these are just some of the ethical issues that we also need to be aware of. Okay, let's consider some cases pertaining to ethical issues and power imbalances. One of the cases we should be familiar with would be Tapuhi and Leuwenberg, number 2. This involved a dispute between two sisters about the distribution of the proceeds of their mother's estate. The mediation involved one of the sisters who lived abroad, and because that sister lived abroad, it had to be conducted by phone. Now, both sisters were apparently obviously legally represented at the mediation. Now, the mediation involved a lot of discussion and negotiation pertaining to complex commercial and taxation issues. And at about 8 p.m., there was an agreement that was reached. But in this particular case, the overseas plaintiff sister told the mediator that she wanted expert legal advice on the settlement, given the complexity of the legal matter. But the mediator proceeded to draft an agreement without the need for tax advice being included as an express term of the settlement. So in other words, a draft agreement was drafted by the mediator, without the discussion about the need for tax advice, even though the sister who had lived abroad had asked expressly that she first wanted to legal advice pertaining to taxation issues before she entered or she signed a document. So there was evidence that the mediator forced the parties to execute the agreement, and he said words to the effect of, "You have got to stay. You have got to do the terms of settlement tonight. No, we are doing it now. We are signing up tonight as this is the only way to do it," and so on. So there was, in a sense, really strong pressure coming from the mediator. However, ultimately, the plaintiff dropped the action to have the settlement set aside. So at the end of the day, she could have impugned the mediation agreement as being void on the basis of her vitiated consent, because she could have argued that her consent was given on the basis of undue pressure, for example, or undue influence. So, but because she dropped that part of her action to settle, to set aside the settlement, what then happened was that the court no longer commented on some aspects of the mediator's behavior. However, the court did suggest that the mediator exerted undue pressure on the plaintiff and her lawyers to sign the settlement agreement that night. So this is an example of power imbalances on the part of the mediator, really trying to pressure the parties to reach an agreement. And in this particular case, the plaintiff would have been well within her rights to file a complaint against the mediator if the mediator was accredited under the National Mediator Accreditation System. There was almost a similar case, the case of Pitorino and Maynard, which I discussed last week. And again, not only is this a question of the enforceability of settlement agreements, but the question also of undue pressure and power imbalance. So, and in this particular case, the mediation was conducted by a court registrar. At the end of the second session, a handwritten agreement was drawn up that set out the terms of the settlement, and this was signed by all parties and the legal representatives. But the court, and although there were the question was raised as to whether or not the agreement was void because there was undue pressure on the plaintiff. Ultimately, the court held that the settlement agreement was valid. It was upheld. There was no pressure on the part of the plaintiff when the agreement was signed. The executor was never told that the plaintiff was in pain or that she was unwilling to sign the agreement. The mediation was conducted with an acrimony, but with a clear objective to reach an agreement. The registrar had conducted herself in a neutral manner, and the plaintiff never said she was in pain or unwell, or that the plaintiff appeared to have good legal advice throughout the mediation. Now, what these two cases suggest to us that although the parties might reach an agreement, it may still be possible, based on these cases, for one or both of the parties who has been affected to argue that the agreement is void and should be set aside because the consent of that party was not freely given on the basis of the fact that there might have been undue pressure. So where it can be shown that there was undue pressure that was exerted upon one of the parties, who was then in a sense compelled or coerced or pressured to sign a settlement agreement, it is possible that a court may set aside that agreement if there is a finding that the consent was given solely on the basis of undue pressure, which means that the consent would then be vitiated, and then making the contract a voidable one. It becomes voidable. It is valid until voided by the party who argues or claims that there was undue pressure in terms of the provision of consent. So we've covered some of the ethical issues in relation to mediation proceedings. We also need to look at the role of lawyers as mediators. So we have the Australian Solicitors Conduct Rule of 2012, which applies to all Australian solicitors across all jurisdictions. This provides a framework for ethical decision-making about what solicitors do every day. It promotes long-standing values of the legal profession and ensures the integrity of the administration of justice for the community. It highlights ethical and professional conduct to be expected of solicitors. It provides for rules of professional conduct, and then the requirement that the solicitors act in the paramount interest of the administration of justice and serve the interests of their clients. Now, under the Australian Solicitors Conduct Rules, there are rules on confidentiality, which we've covered in the previous week, that in general, a solicitor should not disclose information that he receives in the course of working as a solicitor, but a solicitor may disclose confidential client information if the client expressly or impliedly authorizes disclosure, the solicitor is permitted or is compelled by law to disclose, the solicitor discloses the information in a confidential setting for the sole purpose of obtaining advice in connection with the solicitor's legal or ethical obligations. The solicitor discloses the information for the sole purpose of avoiding the probable commission of a serious criminal offense. The solicitor discloses the information for the purpose of preventing imminent serious physical harm to the client or to another person, or the information is disclosed to the insurer of the solicitor, law practice, or associated entity. Now that we know that there is in fact a rule on confidentiality, what then happens if a solicitor is made aware that the client has been making a falsehood or has made misrepresentations to another party, so made misrepresentations of falsehoods, and the solicitor becomes aware of this? What then must the solicitor do, given that he is bound, or he or she is bound by the rules on confidentiality under the Australian Solicitors Conduct Rules and the common law rule on legal professional privilege? Now, under the Australian Solicitors Conduct Rule, under Section 20, in particular in relation to delinquent or guilty clients, it provides that a solicitor who, as a result of information provided by the client or a witness called on behalf of the client, learns during a hearing or after judgment of the decision is reserved, and while it remains pending, that the client or a witness called on behalf of the client has lied in a material particular to the court, or has procured another person to lie to the court, has falsified or procured another person to falsify in any way a document which has been tendered, or has oppressed or procured another person to suppress material evidence upon a topic where there was a positive duty to make a disclosure to the court, then he or she must advise the client that the court should be informed of the falsification and suppression and request authority so to inform the court, and refuse to take any further part in the case unless the client authorizes the solicitor to inform the court of the lie, falsification, or suppression, and must promptly inform the court of the lie, falsification, or suppression upon the client authorizing the solicitor to do so. So this is the requirement that a solicitor must do. Now, however, you will notice that under section 20.1.5, the solicitor may not inform the court of the lie, falsification, or suppression without the consent of the client. What the solicitor can do at the minimum, if the client refuses to give consent to the solicitor to inform the court of a falsehood, is that the solicitor must refuse to take any further part in the case. But the solicitor is not permitted to inform the court of the lie, falsification, or suppression without the consent of the client. We remember that under the Evidence Act of 1995, Commonwealth, for example, under the rules on confidentiality, evidence is not to be adduced if, on objection of a client, the court finds that adducing the evidence will result in disclosure of confidential information made between the client and the lawyer, etc. So again, this is very much related to the Australian Solicitors' Conduct Rules, that even if a solicitor is aware of a falsehood or a lie made by a client, that solicitor is not permitted to inform the court against the objections of the client. The most that the solicitor can do is to refuse to take further part in the case and properly advise the client that the court should be informed of the lie, falsification, or suppression. There's another rule in relation to that, in relation to the rules of the Queensland Bar Association, and it provides that a barrister must not knowingly make a false statement to the opponent in relation to the case. A barrister must take all steps necessary to correct any false statement unknowingly made as soon as possible after he becomes aware that the statement made was false. This rule was relevant in the case of Legal Services Commissioner Ed Mullins, where in this particular case, the barrister Mullins acted as a legal representative for a party in a mediation. Shortly before the mediation, the barrister became aware that his client, a quadriplegic because of an accident, had cancer and therefore had a reduced life expectancy, which would have affected the amount of damages that that client could receive from the other party. The barrister indicated to his client that this information, because it was relevant, should be disclosed to the insurer. But the client did not want the information disclosed. The barrister discussed the matter with the senior counsel, who took the view that if he did not mislead the insurer, but did not disclose, he would be complying still with his professional obligations, because misleading is one thing, but failing to disclose is just an omission. Misleading is an active process. However, it was the finding of the Legal Services Commissioner that because the solicitor continued to rely on reports as to his client's life expectancy without bringing to the attention of the other party that there was cancer, which therefore meant a reduced life expectancy on the part of his client, the barrister was guilty of professional misconduct in violation of sections 5.1 and 5.2 of the rules of the Queensland Bar Association. The barrister should have drawn the other side's attention to the change. In Legal Practitioners Complaints Committee and Fleming, it was noted that the conduct of a practitioner might be regarded as misleading because an affirmative statement is made in circumstances which required qualification. And in this context, misleading and professional conduct might also be made out where a practitioner states a partial truth or in the context of making a statement of fact omits relevant information. It might extend to statements which are literally true, but where a qualification is called for, or where a statement initially true becomes false in the course of negotiations. and in some circumstances, the duty not to bring the legal profession into disrepute and fairness to an opponent may require that the practitioner draw attention to a particular matter, even where the opponent's misapprehension is not induced by that practitioner. So again, this just emphasizes the role of lawyers who are involved in mediation proceedings, that there must be a requirement compliance with honest disclosure. So lawyers who are involved in mediation proceedings always need to be conscious of their ethical and legal obligations as solicitors. Now, I mentioned at the start of this lecture video that there may be cases, well, that in the first place, mediation is not, the mediation profession or industry is not regulated. So therefore, anyone can claim to be a mediator. Anyone can also claim to be an accredited mediator, although the mediation accreditation might actually not be from, might not be according to the Australian National Mediator Accreditation Standards, but could be based on an accreditation system from some overseas jurisdiction, which can potentially mean that that accreditation may be dodgy. In the same way that some people may claim they have doctorates, but those doctorates are actually coming from diploma mills, or they could just buy a doctorate, for example. So it's possible, because that's it's possible that somebody can claim to be an accredited mediator, for example, and in fact the accreditation is pretty dodgy, or something that a mediator who is unqualified simply bought. There is, however, a requirement under the Australian Consumer Law, and in particular the Competition and Consumer Act of 2013, that individuals must not in trade or commerce engage in conduct that is misleading or deceptive, or is likely to mislead or deceptive. So there is a law that prohibits misleading or deceptive conduct on the part of any individual who engages with a consumer. So this law applies even if that individual, a mediator, for example, does not intend to mislead or deceive anyone, or that no one has actually suffered any loss or damage as a result of the conduct. It is a requirement that individuals who engage, people who engage in a profession or in trade who deal with consumers must not engage in misleading or deceptive conduct under the Australian Consumer Law. Now, finally, we talked about the fact that oftentimes a settlement agreement, well, if it is a settlement agreement, in other words, there is a contract, it becomes valid. But there may be times where a contract may be set aside because they could be void by statute, void at common law, or because it can be an illegal contract for being contrary to public policy. Now, we've kind of talked about initially about void at common law, for example, on the basis of the fact that there might be a lack of consent in relation to a settlement agreement, because the consent of a party was given solely on the basis of coercion or undue pressure. But there's another point I'd like to highlight here in this discussion, because remember what we said was that in relation to mediation proceedings, it is commonplace for the parties to enter into a confidentiality agreement with the mediator as well as the other party. And we said that there can be questions about the way that the mediation proceedings were conducted. And if so, if the mediation proceedings were conducted in a way that show that there was undue pressure, or that the mediator did not conduct himself or herself in a manner to be expected under the National Mediator Accreditation System, the question then is, how then can the rule on confidentiality be attacked? And one way of this is to look at the common law, for example, the Australian Consumer Law, where it provides that a term of contract is void to the extent that it purports to exclude, restrict, or modify any of the statutory consumer guarantees arising under the ACL. Now, this is crucial because we remember in week 9 that there is oftentimes common law immunity on the part of the third party neutral. There's also statutory immunity, but in relation to common law immunity, maybe on the basis of agreement between the parties, it may, and because in many of these mediation agreements, there is a provision that the parties hold the mediator free and blameless for on the basis of any legal proceeding, and that there should be no claim that could be made against a mediator. However, given the fact that a mediator, that the agreement between the mediator and the participants in the mediation proceeding may be considered to be a consumer contract, and it may be possible that under Section 64 of the Australian Consumer Law, that particular provision may be attacked for being void because it purports to exclude, restrict, or modify any of the statutory consumer guarantees arising under the ACL. It can also be attacked or impugned on the basis that it is void at common law for being contrary to public policy, such as those contracts which constrain clauses, which have clauses that seek to oust the jurisdiction of the court, where, for example, it provides that none of the parties can seek recourse to the court, no matter, however a mediator may behave. That might be considered void of common law. They may also be considered to be illegal contracts for being contrary to public policy, the contracts such as to commit a crime, contracts prejudicial to the administration of justice, and so on. And so with that, on completing this topic, you should be able to discuss and explain standards of competence and practice, some professional registration and accreditation issues, ethical standards of behavior, particularly mediators and lawyers involved in mediation, and relevant case law, including the Mullins case. And with that, I thank you for watching this lecture video. Bye.